Since the question before the court was whether or not the police conducted a search under the Fourth Amendment, Justice Kagan, who wrote the majority opinion, details the issue. The Fourth Amendment protects individuals' reasonable expectation of privacy, and governmental intrusion into the private spheres generally qualifies as a search. That's from Carpenter v. United States. The amendment's basic purpose is to safeguard the privacy and security of individuals against arbitrary invasion by government officials, and it was designed to place obstacles in the way of permeating police surveillance. That's from the United States versus DeRay. The Fourth Amendment doesn't say anything about privacy, but more on that later. It is designed to safeguard our security from arbitrary invasion by government officials. Did you notice that Justice Kagan uses precedent rather than the actual language to support her position on what the Fourth Amendment says and does? In Carpenter, this court held that accessing cell site location data constitutes a Fourth Amendment search because individuals have a reasonable expectation of privacy in the whole of their physical movements. Now, the court held in Carpenter that accessing cell site location information is a search under the Fourth Amendment. This makes sense because cell phones didn't exist when the Fourth Amendment was ratified. This is the type of controversy the federal judiciary was designed to resolve. But since the Fourth Amendment makes no mention of privacy, how did the Carpenter court come to this decision? The court reasoned that CSLI provides a detailed and encyclopedic portrait of persons' whereabouts, and with that, an intimate view into a person's life. Because people compulsively carry their cell phones all the time, the court explained, a cell phone tracks nearly exactly the movement of its owner and thus faithfully follows him not only through public thoroughfares, but into private residences, doctor's office, political headquarters, and other potentially revealing locales. An interesting, if somewhat convoluted way for the court to come to its conclusion. How about the fact that once I purchase a cell phone, it becomes one of my effects? Or the fact that I contract with another entity, in Mr. Chaudhry's case, Google, does not change the fact that the cell phone is part of his effects, which the Fourth Amendment requires to be secure from unreasonable searches. The court further observed that the newly found tracking capability that CSLI gives the police runs against everyone, not just those under investigation, and travels back in time, making possible a form of surveillance that would have been unknown prior to the digital age. Carpenter accordingly held that allowing government access to cell site records contravenes expectations of privacy. I would say that unwarranted searching of data related to me, my phone, and my interactions with the service provider constitutes my effects and therefore are to be kept secure from unreasonable searches. The government's argument that accessing only a short amount of cell phone location information does not count as a Fourth Amendment search fails. Even short-term monitoring can provide a wealth of detail about a person's familial, political, professional, religious, and sexual associations. And this court has never understood the Fourth Amendment protections as kicking in only once an intrusion goes too far. That's from Pennsylvania Coal Company versus Mahone. Where the Fourth Amendment applies, it applies regardless of the quality or quantity of information the government obtains. That's from Kegel v. United States. That approach makes all the more sense when, as with location history, law enforcement officials can select the time-limited set of materials they want from an all-encompassing database. The government's argument that they only collected a little bit of data makes as much sense as claiming someone's only a little bit pregnant. The government argues that the so-called third-party doctrine precludes Chaudhry from invoking the Fourth Amendment's protections. The idea is that in authorizing Google to collect, retain, and use his location information, Chaudhry lost his legitimate expectations of privacy and therefore his right to complain of a search. Ah, the old third-party doctrine. This laughable idea of previous court came up with that when you give your papers or effects to a third party, it loses all Fourth Amendment protections. Of course, this has nothing to do with the Constitution, only the court's twisted logic to promote the violation of your rights. But not all the time. But Carpenter refused to apply the third-party doctrine to CSLI, and no good reason exists to reach a different result for location history. In Carpenter, the court rejected application of a third-party doctrine to CSLI because such information is qualitatively different from telephone numbers and bank records. It is incomparably revealing and is not truly shared, as one normally understands the term, given that cell phones are indispensable to participation in modern society. So it's not that the third-party doctrine is a wholly made-up thing, just that the court thinks it doesn't matter here because cell phones are indispensable to participation in modern society. I hate to tell you this, Justice Kagan, but so are telephone numbers and bank records. The conclusion that a Fourth Amendment search occurs does not resolve the case, because the Fourth Amendment prohibits only searches that are unreasonable. Now, when law enforcement officials undertake a search to discover evidence of a crime, the reasonableness standards generally requires that they seek a warrant from a neutral and detached magistrate, who may issue a warrant only when probable cause is properly established and the scope of the authorized search is set out with particularity. The warrant issued here, as described earlier, was an uncommon multi-step one, and the parties have contested the legality of each stage of the search process it authorized. The Fourth Circuit did not address the questions that unusual warrant raises. Because this is a court of review, not of first review, the court leaves it up to the Court of Appeals to decide whether, at each step of the search process, the warrant satisfied the Fourth Amendment's requirements of particularity and probable cause. So SCOTUS agrees that Chattrie's data was searched under the Fourth Amendment, but leaves it up to the Court of Appeals to determine if the warrant was valid.